Law Seeko's thorough newspaper analysis for 27th of January 2024. Chale, we'll start with the today's agenda where we'll be talking about some editorial section which is related to what are incestuous Sapinda marriages and why has Delhi High Court reaffirmed the ban on them. Then we'll be discussing as per our schedule the news update and the legal news update. So we'll be starting first of all with the context of this particular editorial where the Delhi High Court this week rejected a challenge to the constitutionality of sections 5 subclause 5 of the Hindu Marriage Act, which prohibits marriage between two Hindus if they are sapindas of each other unless the custom or usage governing each of them permits of a marriage between the two. So what has happened in its order passed on January 22nd on a petition filed by a woman who had been trying for long to have this section struck off, the court said, if the choice of the partner in a marriage is left unregulated, incestuous relationship may gain legitimacy. So what is Sapinda marriage? Let us first discuss that. So a Sapinda marriage is one between individuals who are related with each other in a certain degrees of closeness. Sapinda relationship for the purpose of Hindu Marriage Act as defined under section 3. So let us discuss section 3 of the act. Two persons are said to be Sapindas of each other if one is a lineal ascendant of the other within the limits of Sapinda relationship, or if they have a common lineal ascendant who is within the limits of Sapinda relationship. So what is, in the layman language we can understand here is, from the mother side, a Hindu individual cannot marry anyone who is within 3 generations of them in a line of ascendant. On the father's side, the prohibition applies to anyone within 5 generations of the individual. In practice, this means that from the mother's side, one individual cannot marry their sibling first generation, second generation, their parents, their grandparents, third generation, or an individual who shares this ancestor within 3 generations. On the father's side, this provision would extend to their grandparents, grandparent, and anyone who shared this ancestry within 5 generations. So if a marriage is violative of section 5 subclause 5 of the Hindu Marriage Act and has been in a Sapinda marriage, then there is no established custom that allows such practice. It will be declared void. This would mean that the marriage was invalid from the very beginning and will be treated as if it never took place. So I hope we are clear with this, that what is Sapinda marriage first, why it is prohibited second, and what is the nullity of marriage, whether it would be void, voidable, and it would be void incepto. Now, is there an exception to Sapinda marriage? Yes. The sole exception can be found within the same provision as noted above. It arises when the custom of each individual permits the Sapinda marriages. So this is an exception to this particular principle. A custom may not be protected even after these conditions are fulfilled. The rule in question must be certain and not reasonable or opposed to public policy. Now, on what ground the law has been challenged? So in 2001, the woman's marriage was declared void after her husband successfully proved that they entered into Sapinda marriage, and then the woman was not from the community where such marriages could be considered as custom. The ruling was challenged before the Delhi High Court, which was dismissed in appeal. The woman then approached the High Court again, challenging the constitutional validity of Sapinda marriages. She argued that Sapinda marriages are prevalent even when there is no proof of custom. Hence, section 5 subclause 5, which prohibits Sapinda marriages unless there is established custom, violates the right of equality which is established under Article 14 of the Constitution. The petitioners also argue that the marriage had received the consent of both the families, which proved the legitimacy of marriage. Now, this was the grounds of challenge from the petitioners. But what Delhi High Court said on this, it did not find any arguments merit on this argument. A bench of acting CJ Manmohan and Justice Manmeet Pritam Singh Arora held that petitioners did not provide stringent proof of an established custom which is necessary to justify a Sapinda marriage. With this mind, the court held that women did not present any concrete legal ground to show that the prohibition against Sapinda marriages was violative of right to equality. And Sapinda marriages allows in other country also. So in several European countries, the law and relationship that are considered incestuous are high, less stringent than in India. In France, the crime of incest was abolished under the Penal Code of 1810. The code was enacted under the Napoleon Bonaparte and was also enforced in Belgium. Portuguese law also does not criminalize incest. The Republic of Ireland recognized same-sex marriage in 2015, but the law on incest has not been updated to include the individual in same-sex relationship. So what has happened here is Delhi High Court has reaffirmed the principle that Section 5 subclause 5 of the Hindu Marriage Act is absolutely constitutional, valid. Now, coming up to the national news of the day, Canada officially adds India to its probe of election meddling. So, Canada Federal Commission of Inquiry into Foreign Interference will scrutinize claims that India allegedly intervened in its last two general elections. Now, last year, Canada Prime Minister Justin Trudeau initiated an inquiry following the leak of intelligence document to the media. So, Canada officially adds India to its probe of election meddling. Chief Minister M.K. Stalin inaugurates Jallikattu Arena Stadium. Tamil Nadu Chief Minister M.K. Stalin inaugurated Jallikattu Stadium in Madurai district, named after his late father M. Karunanidhi. Jallikattu, a traditional bull stamping festival, was temporarily banned in Tamil Nadu from 2014 to 2016, but was allowed again following protest and enactment of new laws. Now, let us understand about Jallikattu. Jallikattu was temporarily banned in Tamil Nadu from 2014 to 2016 following the Supreme Court order. There was a massive protest against the ban in 2017. Tamil Nadu enacted the law to override the ban. In May last year, the Supreme Court reaffirmed Tamil Nadu state law allowing Jallikattu. So let us understand some facts about Tamil Nadu. Capital is Chennai. Governor Mr. R.N. Ravi. Chief Minister Shri M.K. Stalin. Language Tamilian and region South India. Now, President inaugurates Kaushal Bhavan. So, President of India, Srimati Draupadi Murmu has inaugurated the Kaushal Bhavan, a symbol of India's unwavering dedication to empowering the country's youth skills. Under the Pradhan Mantri Kaushal Vikas Yojana, skills such as drone operation and mine surveying were showcased. So, President inaugurates Kaushal Bhavan, a testament to commitment to empowering the youth through the skills. Ex-Karnataka CM Jagdish Shettar returns to BJP after joining Congress last year. So, former Karnataka Chief Minister Jagdish Shettar, who had quit the BJP to join the Congress and ahead the state assembly post, rejoined his old party. Shettar cited his long association with the BJP and said many of his well-wishers wanted him to come back to the party. Now, NITI government launched Forum for Advancing Climate Resilient Agri-Food System. So, NITI Aayog, Ministry of Agriculture and Farmer Association and Food and Agricultural Organization of the United Nations of Wednesday jointly launched the Investment Forum for Advancing Climate Resilient Agri-Food Systems in India. The initiative aims to develop an investment and partnership to advance climate resilient agri-food system among the government, private sectors and farmer organization. Now, let us understand some good facts about NITI Aayog. It was formed in 1st January 2015, 9 years ago. Preceding government agency was Planning Commission, jurisdiction Government of India and headquarters New Delhi. Shri Narendra Modi is the chairman of person of this particular, organization. Suman Beri, vice chairman, and BVR Subramaniam, CEO. Now, All India Police Commando competition began. So, international, the 14th All India Police Commando competition organized at Andhra Pradesh Greyhounds training facility began on Monday. Around 16 states have sent their allied commando forces for the competition, including forces such as Special Operation Group from Odisha and Chhattisgarh, C-60 from Maharashtra, the parliamentary forces such as BSF, CRPF, Assam Rifles, IDBP, RPF, SSB, and CIF. The team will comprise 13-15 commandos, and the competition will be held in 5 phases across 1 week, wherein the participants' skill, endurance, and teamwork will be tested. Now, Justice Shri P.B. Varlale, sworn in as the Supreme Court judge, Dalit representation in Supreme Court rises to 3. So, Justice Prasanna B. Varale was sworn in as a judge of the Supreme Court. Chief Justice of India, Shri D.Y. Chandrachud, administered the oath of Justice Varale, who has previously the Chief Justice of Karnataka High Court and the Judge of Bombay High Court. With this appointment, the Supreme Court is back to its full strength to 34 judges. Also, the Supreme Court now has 3 judges from the scheduled caste, Justice B.R. Gavai, Justice C.T. Ravi Kumar, and Justice Varale. Now, let us come up to the legal update where the Supreme Court rejects challenge to center notification bringing medical devices within the definition of drugs. Supreme Court has declined to interfere with the Delhi High Court ruling, which upheld the central government notification to include medical devices such as nebulizer, blood pressure monitoring devices, digital thermometers, and glucometers as drug. The point is that this has not been done for the patient safety because it is not notified completely, goes out of the range of regulation. The idea is actually to protect the patient safely. The object really is to promote patient welfare and safety to ensure that people are not for this kind of things. And the case name is Surgical Manufacturing and Traders Association versus Union of India. Now, members in default of membership fee stand disqualified from society without notice. They are not entitled to vote. The Supreme Court held that as per Section 15 of the Society Registration Act, disqualified members would not be entitled to any notice as they had no right to vote or to be counted as members complainant. The court opinion that specific language uses that such members in default of membership fee would not be entitled to vote and would not be counted as the members of the society. And the case name is Advocate Baba Sahab Vasade and another versus Manohar Gangadhar Mudheshwar and another. That's all for the today's news update. Thank you so much for watching. Take care.